Welcome everybody to this very special MyHR live event. I'm pretty happy to be joined by two of Australasia's best employment law experts. In my view, we have Rosemary Wooders, partner from Bell Gully, the best employment law team in New Zealand for my money. And we have Julian Hackenberg, who is the MyHR HR lead for Australia, based in Sydney. And Julian brings to this discussion a really unique perspective of life under modern awards, which of course is the Australian equivalent of the fair pay agreements. I have a little bit of experience in HR and employment law myself. I'll be offering some of my views, but I will also be playing the role of sort of moderator, a devil's advocate, somewhat asking questions of Julian and Rosemary as well. And I am Jason Enor, the CEO and co-founder of MyHR. As usual with the events like this, we do record them and we will edit and then publish them after the event on the myhr.works website and through our social media channels and YouTube, etc. So you may view them and share, view it and share it afterwards. If you have questions after the event, please reach out. There's easy ways to get in touch with our team through the contact links on our website. So please, you can ask questions afterwards. And there is also the opportunity to ask questions live, and we will do our best to answer those. Our commitment to you is if we cannot answer something, we will go away, investigate it and come back. We will never attempt to answer something that we're not 100% certain on, but our live questions are always welcome. In terms of the format today, I've just introduced the panel, who we are and what we do, what we bring to it. We're going to go through a sort of series of key topics around the fair pay agreements, which come into force, or the legislation at least turns up formally tomorrow in New Zealand. That's the 1st of December 2022. I guess what I want to make clear in terms of what this webinar is aimed to achieve is some practical tips and guidance for right now. What do we do now as New Zealand employers, and what should we be doing or preparing for in the context of fair pay agreements? This is not an opinion piece. This is not a discussion about the merits of fair pay agreements or otherwise and the politics surrounding it. It's an incredibly contentious topic. What we hope to do today is just park opinions for a moment and just get into the practical reality with a view that we can help you as New Zealand employers navigate this new world. We will make some comment on the likelihood of a change of government at next year's election, because there's a whole lot of commentary around that, and that creates some uncertainty for employers. And so we will share views on that to maybe help you. But just to be clear, we are trying to give you some practical tips and guidance around fair pay agreements rather than just bore you with our political opinions on them. So with that in mind, I'm going to dive in. We're going to start with Rosemary, because as an employment lawyer and expert in all things employment law, Rosemary has an amazing handle on the legality of the fair pay agreement. What is it? What does it mean? And has prepared for us a bit of a summary on this. So Rosemary, if you'd like to kick us off by just telling the audience what these things are.
Absolutely. Thank you so much, Jason, for the introduction and for inviting me today. So as Jason mentioned, I'm an employment lawyer at Bell Gully. I'm a senior associate, and over the past year or so, we have been advising clients on the Fair Pay Agreement bill and also what that may mean for them. So we've done a bit of kind of practical planning and thinking around how employers can best prepare for fair pay agreements. So as Jason mentioned, the Fair Pay Agreements Act will come into force tomorrow. So the timing of this webinar today is absolutely apt. In short, the Act provides a framework for collective bargaining for fair pay agreements across entire industries. So what I mean by that would be, for instance, all butchers in the supermarket and grocery industry, or occupations, such as just all butchers, rather than being caveated by a particular industry. So the purpose of a fair pay agreement will be to provide for minimum binding terms and conditions for employers and employees in a particular sector or occupation. These terms and conditions will be set through a system of industry or sector-wide bargaining between unions, as between union bargaining parties and employer bargaining parties. And if the parties are unable to reach an agreement on the terms and conditions of a proposed fair pay agreement, the matter will in all likelihood be referred to the Employment Relations Authority for a decision, and the decision of the Employment Relations Authority, of which they will decide what the terms and conditions of the fair pay agreement should be, will then be imposed on everyone covered by the coverage clause of that fair pay agreement. Now, as many of you will be aware, we've already got an ability for collective bargaining in New Zealand, and that it can either be implemented or initiated, I should say, by an employer or a union, and that agreement would apply as between those bargaining parties. If the parties cannot reach an agreement, there is currently no ability for the authority to make any decisions as to what the terms and conditions of that collective agreement should be. So, the nature of a fair pay agreement regime completely changes that landscape because you're dealing with industry wide bargaining across New Zealand, and then with the potential that a third party could set the terms and conditions. Today, I'll just briefly discuss what the required terms and conditions are for any fair pay agreements, if any are eventually agreed, and then at a high level, the process for initiating and bargaining a fair pay agreement. Now, before I get into that level of detail, I'm sure many of you may be asking the question, well, why do you need to know about fair pay agreements if you don't have any union membership in your organisation and have never had a collective agreement? Why bother learning about this? In short, if employers have employees who would be covered by the proposed coverage clause, those employers will be covered whether those employees are union members or not. And if an employer does not want to be part of a fair pay agreement, the answer is tough luck. Unfortunately, you can't opt out of a fair pay agreement once they have been agreed to. So, just briefly, a brief mention on terms and conditions of a fair pay agreement and what they must contain. This is a common question that we have had from clients. So, in short, a fair pay agreement must include the commencement and expiry date, and the commencement expiration, so the term of a fair pay agreement, can be anywhere between 3 to 5 years. The fair pay agreement must also include a coverage clause. So, by that, that's very similar to the concept of a coverage clause in a current collective agreement, for instance, albeit it would apply across the board, across various industries or occupations. It
So
must also,
Rosemary, sorry, if you don't mind me asking a question
absolutely,
then on that, I think because our audience are largely small and medium employers. So many, in fact, almost all will have never had collective agreements or union activity in their workplace. Some do, no doubt, but the vast majority don't. So this is very new ground for them. And when you talk about coverage, and I'll use your example of the butchers because it's quite a good one. Unfortunately, there aren't that many independent butcher shops left. They used to be pretty cool things where you get, a real personalised service, but they do still exist. So I'm a butcher, I've got 5 staff and I operate a suburban butchery. I don't have anything to do with the big supermarkets and their work. They go away and negotiate this fair pay agreement. And you're saying those terms now apply to me. I have no option to opt out. I am part of a butcher's fair pay agreement covered by this negotiation process of which I've had no involvement. That's what you're saying in practical terms, right?
absolutely. In a nutshell, Jason, you've summarised that perfectly well. There are, I guess, two instances just to flag where a butcher may be able to delay joining an FPA for a period of time, and that's if there is serious, significant financial hardship, and that delay will only be for a 12-month period. So it's not by any means automatic that you would get that delay if you were the butcher. It may also be possible as well to negotiate different terms based on region for wages. So, for instance, if you were based in, I'm just going to use Bluff by way of example, compared to a butcher in a high end suburb in Auckland, there may well be some different wage rates, and there is the ability to negotiate different wage rates in an FPA. But
Okay.
unfortunately, the short point is yes, if you are the butcher, you are caught.
Wow. But as that bluff-based butcher, I'd have to engage in the process, which potentially I may not have time or capacity to because I'm busy running my butcher shop, and then these terms would just then roll out to me. So that's
Absolutely. And
okay.
in term,
Thank you.
just picking up on that word engagement, Jason, and it's a really good, I guess, point you refer to. So a number of our clients have said, well, how can we get involved in this process? And, what is our involvement in terms of the bargaining process? Employers don't necessarily have a voice at the bargaining table for any FPAs. So, in order to be represented and try and at least have some kind of indirect input into these negotiations, they would have to align with an employer organisation or an eligible employer association. And that eligible employer association would in effect represent the interests of a number of employers across the board who are their members, and they also have to represent the interests of all other covered employers. And that eligible employer association has got a duty to at least communicate with those employers who it considers are likely to be covered by the collective agreement and obtain opinions from those covered employers. But it's not necessarily the case that that will then translate into your opinion as that butcher and bluff being communicated at the bargaining table.
Yeah. Okay. Wow. That's okay. That's There's quite a bit to dive into there, and we've got 4 questions which relate to that. I think
Yeah.
I've sent us on a little bit of a tangent around coverage, but I just wanted to clarify that. How about we finish with what you were saying in terms of the content of fair pay agreements, and because I think that's going to be really useful to help us understand what it covers around wage rates, overtime, etc. And then we can dive into this rollout and practical realities piece because the questions relate to some of those things we were planning to discuss anyway. So I'll be quiet now, Rosemary, and I'll let you finish your bit on the content of a fair pay agreement.
No, absolutely. And for those of you in the audience as well, please do feel free to reach out with any questions that you've got along the way. And I'm sure between all three of us, we'll do our best to cover those questions during this session. So, as well as the coverage, the Fair Pay Agreement must also include standard hours of work. Now, what standard hours of work for one employer could be vastly different to someone, for instance, based in Auckland, who's significantly larger business. So, what standard hours of work is for a matter of negotiation. But I think where that gets to, and based on reading around what standard, the purpose of including standard hours of work are to try and decide when overtime rates may be triggered or penalty rates. So I think in practice, you may end up with an agreement that says, look, standard hours of work are 8 hours per day. Anything over that will be treated as overtime. And then there'd be a negotiation around what overtime rates may look like. In addition to standard hours of work, the agreement must also include things like pay, so base wage rates, overtime provisions, as I mentioned before, penalty rates. So, for instance, if someone works in a weekend, there may be some negotiation and discussion around having a penalty rate for weekend work or night work. There must also be superannuation, leave entitlements, and one of the more broader categories is training and development. There's very little guidance as to what specifically training and development should refer to, but that term must be included in an FPA. Um, there are also a number of other topics that must be discussed as part of fair pay agreement negotiations, but they're not mandatory. Our view is that it is, in all likelihood, if these terms don't end up in a fair pay agreement, the bargaining side, probably the employee bargaining side, will likely bring a claim in the authority, that's the Employment Relations Authority, and say, hey, look, we were trying to negotiate in this non-mandatory topic, but the other side was not willing to include it in that agreement. Authority, please decide whether this term should be included. So the topics I refer to here are topics such as redundancy entitlements, health and safety requirements, and flexible working arrangements. So there are a wide variety of matters that ultimately could end up in an FPA. Now, just before we move on, one question that is often asked is, well, does that mean a fair pay agreement is going to replace collective agreements and individual employment agreements? No, that isn't the case. Rather, it will be the effectively the better of test. So, if, for instance, you've got a better wage rate in your individual employment agreement, but you don't have any redundancy provisions in the employment agreement, and yet you've got them in the fair pay agreement, the wage rate in the individual employment agreement would apply, and then you would apply the redundancy provisions in the fair pay agreement. So it is going to be a bit of admin work on employers to have to work out which terms and conditions and which agreement apply to each employee.
Well, so potentially an employee could be covered by two separate agreements, is what you're saying. And we would
Absolutely.
need to reference each one to determine which had the better terms and therefore which applied.
Correct.
So then a practical reality in just terms of getting on with the day-to-day of life as a small and medium-sized employer who does not have a dedicated HR person there every single day, unless they use MyHR, of course, but that's not what we're here to do. You would probably be better just looking at leveling it. So you could get to a point where just only the FPA applied and then you would reduce some admin. Would that be a solution? Or could you raise the bar across your IEA and then completely negate the need to use a fair pay agreement?
Absolutely. And I think, Jason, that is a tool that a number of employers look at, what a strategy, I should say, that a number of employers are looking at the moment to do. And effectively, if you do have good terms and you are above the market in terms of wages, things like overtime provisions and even redundancy compensation, then it could be possible that the FPA would not be relevant. But there are also other things like training and development, and who knows what that term will entail when it is negotiated into the fair pay agreement. So I suspect that although you can do your best to try and, in terms of those financials,
Mm.
potentially increase those, there are certain other terms I think that you may not necessarily be able to anticipate what they're going to entail.
Sure. Okay. Wow. We're up to about 11 questions, no, 14 questions now. So this is, as we thought it might be, a very hot topic.
Yeah.
I think if we round out your session here, Rosemary, and then we roll into the practical realities and maybe pull in Julian on some of that and address the questions perhaps as we go. So again, if there's anything more in terms of the legalities, just please, yeah, I'll let you wrap up again. I'll zip it.
Yeah, absolutely. So would it be helpful if I just briefly talk about, well, what will happen then on the 1st of December and the actual process itself?
Yeah, let's do that.
Moving on. Yeah.
When we all wake up tomorrow, I think we're all going to feel the same, a bit grumpy about the weather, and our day will sort of kick off like normal. So there's not going to be a massive change tomorrow, but yeah, let's roll into this next part and talk about what it looks like from here.
Yeah, so I guess short point is don't panic for now at all. Based on what we have reviewed and discussions with Business New Zealand, it is very unlikely, probably famous last words, but very unlikely
Mhm.
that we will actually see a finalised, ratified fair pay agreement in action for at least 8 months. And that's because there is quite a long process that the parties have to go through before a fair pay agreement can be finalised. So, as of the 1st of December, we understand that a number of unions have already started preparing proposed coverage clauses, and that's because only unions can initiate bargaining. And there are various thresholds for initiating bargaining, and the onus is on the union to prove that they have met those thresholds. I won't go into those thresholds just now because they are quite technical, but in short, once the union has put in their application for a proposal to initiate bargaining, then it needs to go to the Ministry of Business, Innovation and Employment. MB will then review the application and assess it to see if it meets various required thresholds under the Act. And in terms of that assessment period, MB have got a maximum of 45 days at most, business days, to review and consider the application. And that period can also be extended if MB decides to seek public submissions. For the first 6 months of the Fair Pay Agreement Act being in force, MB has actually got a 6-month period of time to consider and approve applications, just to allow themselves some time if they are inundated with applications. And then once an application has been approved, then it is up to the union to use its best endeavours to try and advise all employer that the unions consider are likely to be covered by the collective agreement, which is a huge undertaking.
Mm.
And then there are various obligations on employers at that point of being advised to inform any unions that may be active in their workplace and any employees who may be covered. And there's various pieces of information, including employee contact details, the employer must then provide to the union representative party.
Okay.
So that is the first step. And then just at a very high level, once that process has been done, then the bargaining sides need to be sorted out. So you've got the union or the eligible employee association, inevitably that will be a union, and then an eligible employer association. And that would be a union that, or it would be an association that is an incorporated society and is got a purpose to promote the collective work interests of the covered employers for the purpose of bargaining. And so there is a 3-month window in which the eligible employer association can be created and developed before bargaining actually commences. And then once you've got the parties together, then you've got the bargaining process, which is very similar to collective bargaining. I can provide further detail if anyone does have any questions, but just in the interest of time, I won't get into too much detail around that. But it's effectively negotiations back and forth. Each party has to consider the other side's claims, and then the employer association has to report back to each covered employer regarding how the negotiations are going and seek feedback from the potentially covered employers. And then, assuming all bargaining goes smoothly and there are no claims or litigation along the way, which we expect is unlikely to be the case that it goes that smoothly, then for the Fair Pay Agreement to be finalised, it must be assessed and approved by the authority and then ratified by a voting process. And each covered employer has got a specific vote allocation depending on the size of the organisation. And then the actual Fair Pay Agreement is brought into force by the Chief Executive of MB through secondary legislation. So
Wow.
that, in a nutshell, is trying to summarise hundreds of pages of Fair Pay Agreement Act.
That's pretty impressive. That's why we run businesses and not government, because we tend to get things done a lot faster than that. But this may assist employers. I think the headline from that is, at the moment, don't panic, but let's prepare. This process is quite drawn out. What I found interesting about that, Rosemary, is there's quite a low threshold to trigger the bargaining for a fair pay agreement, but in terms of number of employees in an industry sector. But it sounds like the threshold to ratify it's a little bit higher. What happens if it doesn't go out to all of the employers covered by this group, or they don't reply? How is that managed in terms of ratification, or objections from employers who don't like what they're seeing out of the bargaining process?
Yeah, so I guess if employers object regarding what they don't like about the bargaining process and they are in the minority, then again, unfortunately it is tough luck. They will still be bound by that collective bargaining.
Okay, and minority
agreement.
majority is based on employee count in industry.
Correct.
Okay, thank you. So that's quite useful in terms of, I guess, what happens now. What I'm keen to know, and if you have any insights, you may not, but the CTU, the Council of Trade Unions, was it last month, I think, were quoted in one of our national papers as saying that they're going to target 6 industries sort of off the bat. And from memory, that included aged care, early childhood, security, I think retail was in there, I'm forgetting the other two, sorry, but it was some of those headline industries where you would expect maybe hospo or fast food. Do you have any indication that that's what we can expect, that these are the industries that are likely to go first?
Yes, we suspect so. So we understand that Unite Union has announced its intention to initiate fair pay agreement for the hospitality sector as soon, well, from tomorrow.
Yep.
And there are also bus drivers, retail
Yes.
workers, especially
Yeah.
grocery, security guards. There is an indication with those particular sectors. And then we suspect cleaners as well will be in there. But interestingly, a lot of cleaners are described as independent contractors or contractors, and contractors aren't currently covered by the Fair Pay Agreement Act. So possibly it will be interesting just to see how that plays out.
Mm.
Um,
Yeah.
with this.
I wonder if in that industry, because that would then, the industries where there's often tension around contractor versus employment relationship, such as drivers in a number of industries, be it Uber, be it couriers, be it trucking companies, the tension exists there in a similar way that tension exists within the cleaning industry. Do you think FPAs would seek to clarify that a little bit more and maybe extend employment rights to people who would otherwise be classified as contractors, or is that outside coverage of the law?
So it's outside coverage at the moment in terms of the fair pay agreement. So I guess what would have to happen in practice is there is a provision under the Act, and it refers to you can't structure or effectively structure an arrangement to try and get out of being covered by the Fair Pay Agreement Act. And there is every indication that, I guess, depending on how this current Act goes, it could well be extended to contractors. But in terms, I guess, if a cleaner, for instance, was classified as an independent contractor, but they wanted to try and come under the coverage of a fair pay agreement, they would have to first of all bring a claim to challenge their status and claim that they're an employee first before
Right.
they move on.
Okay, cool. Thank you. The last thing I'd like to wrap, we're now up to about 21 questions, and I notice some of them are being answered as we go. So I think what we'll do is carry on the flow, because we'll probably knock a few more questions off as we go, and then any that are left we'll wrap up at the end. So before we pass to Julian and just get some insights on day-to-day life with these things, I did want to address, I mentioned it at the start, whilst this wasn't an opinion piece and we're not here to speculate about, the good, the bad, or the political landscape, there is a lot of reporting about National saying they will repeal these as soon as they come in, that this will be this is not legislation that will survive if they come in. I guess what I wanted to put forward for the group, and it goes to your point around don't panic. We don't have to do anything now. There's a long process ahead of us. But I would equally say, let's not be completely dismissive of this and these things and what they mean. Basing your business plan on the potential election outcome is a very dangerous thing to do. And there have been a couple of instances in recent years in England and in the USA where people had a perception of how an election might go, and it didn't quite turn out that way for various reasons. And social media is great at creating echo chambers and bubbles of belief that don't necessarily flow through into reality. So the outcome of the election next year is yet to be determined. And it is still yet to be determined, even if National do win, whether they win with an outright majority or there's some negotiation or coalition going on, which creates a whole spectrum of possibility from not repealing this at all to maybe making some change that leaves us with a hybrid version of FPAs for some specific industries, through to the outright repeal of these. And we just don't know. We can't speculate. And I think it's worth keeping an eye on and maintaining these. If as an employer you have really strong views about this and the opportunity to present those views comes up, I suggest you do it. As MyHR, we are looking at our role in this. We're not a representative. We're not an incorporated society. We're a private limited entity. So our role in bargaining isn't there, but we can certainly act as a voice for small and medium businesses in New Zealand. So all I wanted to do in terms of addressing the election is, we're not considering the repeal outcome at this stage because it's simply too far away. And there are things that will need to happen before that. And if we don't respond to questions, to requests for bargaining, for input on a potential FPA, if we don't respond on the assumption that this will be repealed and it's not repealed, then I think we will all be quite disappointed. So that's all I wanted to say around that. Rosemary, would you agree with me, or you feel free to disagree or propose a different opinion?
Yeah, no, I agree with your sentiments there. Absolutely. I think it would be dangerous to assume that National will get in next year and then not having done any prep for this, and then suddenly you're lumped with the fair pay agreement that you're required to comply with. So I do think it is an important issue. One question that actually has come up from clients in terms of, if it were to happen, that national get in, and assuming nothing, people have asked, well, what would that entail? What happens if we've already entered into a fair pay agreement, and how do you see that pan out? So I guess further to Jason's point, well, at the moment, we don't know. It's kind of just a guessing exercise. But we have heard commentary that we expect there will be some transitional provisions that would enable employers to update payroll systems and communicate with employees on the same before actually a fair pay agreement is removed. So it wouldn't happen automatically overnight either, if that is a concern of employers.
But very hard to remove terms. So if you have a group of employees benefiting from a set of terms, some of which may be a higher base rate in an IEA, but better redundancy provisions from an FPA, and some overtime in an FPA, to just start pulling back terms of employment and disadvantaging people, may be quite hard anyway. You may be left with those terms. And even if the law allows the removal of those things, which would be interesting, it becomes a point of competitive advantage, right? Employers who go, no, we're going to keep all the good terms and just roll that into the post fair pay agreement, individual employment agreement, they're now at an advantage to others. So I think it's still quite messy in that situation. So yeah, thank you for that. Julian, let's dive in. You've never really lived. You're looking at us over the ditch going, I don't know what you guys are all freaking out about. I don't recall a scenario where there wasn't a modern award in place. And modern awards, for the audience who don't know, modern awards are the Australian version of the fair pay agreement. It's the same sort of thing, negotiated by industry sector. Unions are involved. Fair Work Australia is involved, which is Australia's equivalent of the Ministry of Business, Innovation and Employment, more or less. And these things have existed for many, many years and have gone through a number of changes and iterations over those years. So, Julian, really keen, again, on the basis of our kind of always trying to give good quality practical advice to people, is I'm keen for you to give us a bit of a picture of life under the modern award system, and how does it affect things like the hiring process? Any insights you can give, what employers need to be aware of when they engage and hire somebody, what admin this creates, but then once someone is employed, how it affects that. Do you have to sort of constantly refer to these things to figure out what you can and can't do?
Yeah.
It's a source of worry for us, but it's your day-to-day reality. So yeah, could you give us a bit of a view on what life is like under modern awards?
Yeah, no, thanks, Jason. And it's really interesting listening to yourself and Rosemary talk about fair pay agreements and just sort of listening to the similarities and some of the differences. I think for the most part, obviously it does create a headache and administrative burden for so many employers over here. And certainly in recent times, there have been so many employers who have been caught out for breaching modern awards and in turn underpaying their staff. And of course, there's instances where employers have blatantly done that. But for the most part, it's really just been inadvertent, and it's just been administrative errors or payroll errors, or just not having knowledge. And so I've been working in this space for about a decade now, and working with small and medium-sized businesses primarily. And I mean, at first I was really surprised as to the extent of the difficulty with which businesses had with even determining which award applies to their business, and sort of listening to some of the comments around coverage. Similarly, with modern awards, there's a lot of overlap in terms of the award that may apply to a business. So in the hospitality sector, as an example, there's about 4 or 5 different modern awards that may apply, depending on the exact nature of your establishment, whether it's sort of primarily sit-in or take-away, or the location, whether it's located within a hotel or a registered and licensed club, and that sort of thing. So even determining the award that applies to your business is can be, in some instances, a really difficult exercise. And that's before you even get to interpreting the actual document, which, I mean, I was looking at one prior to this, and it's approximately 86 pages long. So, there's not too many employers who are sort of spending their time reading through and digesting all that information just because they don't have the time to do it.
And Rosemary, to bring you in here, because typically an individual employment agreement in New Zealand is somewhere between sort of 10 and 15 pages, maybe pushing 20 in a really complex situation if you're including long job descriptions as well. But do you expect, Rosemary, similar sort of volume in terms of 80 odd pages of content for the Fair Pay Agreement?
I would suspect not. I mean, I could be wrong, but the number of mandatory terms and conditions isn't a huge list by any means. But again, if you've got different regions across the board and different wage rates for each different region, and depending on how many roles and different types of roles there are, so there could be differences in wage rates between your managers versus your assistants. That could have the potential to expand out a fair pay agreement and the length of it. But I guess my best guess is it may potentially be slightly shorter than a standard collective agreement in length.
Thank you. Yeah, it's those levels. Hey, Julian, we deal with a fair bit in Australia. You're level 1 retail worker, you're level 2, you're level 3, and those levels determine what you're paid, and they are defined by a list of duties that you perform. So there's a sort of associated job description in the modern award. So
yeah, totally. And I think what we find is and we work really closely with our clients when they're appointing new hires who might be covered by an award to assist them to determine whether they're covered and what level they might be covered at. And with the idea of these things applying across an industry, sometimes it can be difficult to apply judgment around what a classification says in an award and applying it to this individual employee, because the award's designed to apply across an industry, and it would be quite general in turn, and then you're having to apply a judgment call as to what classification your employee's at, and that can obviously cause some difficulties and even some errors in terms of determining the correct pay rate.
Yeah, that's really interesting. So, and I find that, so there's this whole sort of piece of interpretation, which I'm assuming we will get into in New Zealand when we have multiple fair pay agreements. And there's a question sort of related to this as well. So, for example, if we took a retail fair pay agreement, it does not cover you because you work for a retailer. It covers you based on the description of the job you do, right? Am I clear with that, Rosemary? So let's say we have a small retail network of 7 stores, and I sell apparel of some description or shoes, whatever it may be. And I also have a distribution centre based in the suburbs of Wellington or Christchurch somewhere, and I have pick-pack staff who collect the orders and distribute them out. We are not, as a whole business, covered by the retail award fair pay agreement. We are covered by the retail fair pay agreement for our store staff and by the warehousing and distribution centre fair pay agreement for our warehouse staff. Would that be correct, Rosemary?
So ultimately, it's going to depend on how the actual coverage clause is drafted in the end, particularly if you are looking at industries. So it could well be the case that you could have a supermarket or supermarket and grocery industry, and it doesn't provide any further detail than that. Or you could have an occupation. So I think we're ultimately going to be guided by seeing how detailed MB is actually going to be looking at and assessing those coverage clauses. So you could, in theory, I guess, end up with an agreement that does cover off a number of different roles.
Okay.
So that's still to be decided. I should actually, while we're on the topic of industries defining occupations, etc., regulations were released this week. Can't remember exactly which date. Just talking about how broad the sectors are likely to be. And so the regulations that were made pursuant or that fall under the Act say that any proposed coverage clause must include the Australian and New Zealand standard classification of occupations code, it's a bit of a mouthful, for occupation and industry if a code exists that accurately describes a relevant occupation. Now, admittedly, before I saw this, I had not had a look at this classification document before, and in short, it is, in our view, it is quite an outdated document and doesn't
Right.
necessarily capture all of the various occupations that are out there. So in any event, it is still a start. So it's something that the union will have to become au fait with if they are going to be designing their coverage clause, and they need to
Okay.
make sure that it cross-references with that standard.
We do have some questions related to kind of coverage or what industries may be in or out. So I might get you to send that link through, and we will share it as part of the post-event recording. Julian, I noticed you smiling there a little bit. Is this something you deal with often?
Yeah, totally. There's a lot of parallels, just even with the coverage and interpreting what the intention was around who's meant to be covered and who's not meant to be covered. And just working with a retail business the other day, and they weren't sure whether their warehouse staff were covered under the retail award because the warehouse isn't attached to the retail store; it's more of a distribution center. And then I was sort of working with them whether the storage services award applies to those staff instead. So, yeah.
Wow. Okay.
So
then to just to play devil's advocate for a minute, because we're all quite worried about these things. I mean, they do sound like an administrative nightmare. But is there any benefit? Is there anything you see that can help employers if it's done right? And you can absolutely say no. But when you look at the way New Zealand operates with a whole lot of just individual agreements, a per employee engagement process, unless you have a union and collective in place defined by the workplace, do you look at us with envy at the moment, or do you think there are some benefits to modern awards?
No, I definitely do look at you with envy. I mean, I do think part of the issue with the award system is how it was set up in 2010, because we've had awards for 100 years, and they sort of piece together all these old state-based documents and sort of chunk them together into 120 different awards. I think there's opportunity sort of starting afresh and being involved in bargaining and sort of setting them up so they're really relevant to modern enterprises as they stand at the moment.
Okay.
I think that's probably the main difference between the two systems, and that's probably where I think New Zealand has the leg up on Australia in that sense.
I think that's really good advice then, and probably a good opportunity to wrap into Q&A. So, if I take from what you've said, Julian, we in New Zealand have the opportunity to start from a clean slate perspective and actually build these things right, and not perpetuate a kind of 100-year legacy that Australia's trying to navigate. I think we're definitely seeing that these will, as we suspected, bring an administrative burden. One of the biggest challenges that we're hearing from Julian, and I can hear when the uncertainty in Rosemary's answers around how these coverage clauses may apply, will be around coverage, determining who's in, who's out, and how that is organised. I think as a next steps sort of process, and as a collective of small and medium employers on this call and associated with MyHR, is we will do our best, I suppose, to make our concerns heard, and hopefully that if we are starting from a clean slate perspective, we can build these things in a way that is sensible and practical and reflects the employment reality in New Zealand, not sort of based on some 100-year-old document that's no longer relevant. So I think that's awesome. Thank you, Julian. Thank you, Rosemary. I'll go through some of the questions. There's actually 29 of them. So we might see, we do try to keep these things under an hour, so when they're recorded and played back, it doesn't put people to sleep. But the first one that we've covered around the application of would an IEA apply if there's been does an FPA replace an IEA? And as you heard us say earlier, that there is this selection of the most favourable clauses, and then those things apply. What happens with pay equity claims, and how do these fit in? Rosemary, you might have some good insights on that. Pay equity has been such a big thing for us here recently, and only this week, I lose track of time, another equity decision was released. Do you see them rolling in, and the sort of FPA becomes the mechanism by which pay equity is negotiated, or how do you see this working?
It could be possible. So by no means does the Fair Pay Agreement regime will replace the pay equity regime at all. Rather, that will be a separate process that will continue on. And if it is the case that whatever is concluded with pay equity claims, those terms are better than the FPA, then they will trump the FPA. But likewise, reverse, if the FPA is better, then that will trump.
Okay.
And it could well be the case, again, that fair pay agreement negotiations are used as almost a backdoor to try and increase wages as much as possible. I mean, that's the whole thrust of the fair pay agreement regime, is to try and support those who are not necessarily in the highest paid roles.
Yeah.
And yeah, so we'll have to see how that plays out.
Awesome. So no straight answer to that one. I'm sorry. It'll be a combination of things, but thank you. There's a question about, is there a website showing industries, occupations that fair pay agreements will apply to? Daleen, the answer to that I think at the moment is no, because it's not yet applying to any. But Rosemary, do you know if if MB or biz.gov.nz are planning to have a database? I know in Australia, through the Fair Work Australia website, there's a whole modern awards section, and you can search them. There's a search feature. You can download them and get access to them. Are we building something similar here?
So I don't know whether MB will have a specific list as such, but FPAs will be secondary legislation, and that means that it will be published online. So there will be a database. You'll be able to search for various FPAs and hopefully carry out word searches, but we wait to see what the technology would look like in that regard.
Okay, awesome. This is an interesting one from Hamish around coverage. We've sort of covered it a little bit, and I think, Hamish, the answer is sort of wait to see, but we've focused on retail in our example. This relates to social workers. So we employ registered social workers. We also employ as social workers. We also employ registered social workers in non-social worker roles. Would an FPA for social workers pick up all of those people, or is it going to depend on the terms of the specific FPA? So that's a distinction between, I guess, your qualification and the job you perform. Does coverage cover you based on the job you perform or the qualification you have? Obviously within a relevant industry. Clearly, if you're a doctor working in a butchery, you're not going to be covered by a doctor's award. But there's some relevance here, in that the qualification is relevant to the industry that these people work in, but they are not working in the deployment of that qualification, if that makes sense.
Yeah, I think the short point is it is ultimately going to come back down to how the coverage clause is couched. I suspect that the union will want to make the coverage clause as broad as possible to capture those who do have that qualification and who don't. And it will, I would probably say you may have just a general coverage clause that refers to social worker, but doesn't actually go on to describe whether they're qualified or not, and get into that level of detail.
I think similar to that discussion we're having with Julian around the pay rates or the levels of pay, is linking to a set of duties that you do. And it's on the employer to interpret where that employee fits in terms of that level. Okay, how do we go about setting up an eligible employer association? I like that, Kelly. Let's take some action. What is the process, Rosemary? Do you just register yourself as an incorporated society?
Yeah, so in short, you must have, so you register yourself as an incorporated society, but you must have at least one member who is a covered employer. So if, for instance, Gully Limited decided to set up its own association, it would need to get another member to come and join up. And then it will be an incorporated society, and it needs to have the purpose, so it's quite a specific purpose, to enable association to promote the collective work interests of the covered employers for the purposes of bargaining for a proposed fair pay agreement. So it does need to have that specific purpose as well. And you do need to know who those covered employers will be before you actually set it up. So, for instance, if you decided to be proactive now and set up an association, I would say, well, hold back a moment, because we don't know what the coverage is specifically going to entail yet.
Okay, that sounds like a ring your lawyer. There's a real answer to that, and get Rosemary to set it up for you when we know what it needs to be. Another question just around a list of an inclusive list of industry-specific coverage that is not yet available, but will come as we know more. How do we know? And this is another one around coverage. We're getting a lot of these. So this uses the example of a butcher who does maybe 15 hours in the butchery, but then does 10 hours of a delivery as a delivery driver and 20 hours in retail. So this is multiple different sort of roles with the one employee. Are they covered by different awards, different clauses within the same award, or do we not know?
Yeah, so the Act currently says, so if an employee is covered by multiple FPAs, if at least 25% of an employee's work is covered by an FPA, that employee will be covered by that particular FPA. If there are 2 or more FPAs that meet the 25% threshold, the FPA that covers the largest portion of the employee's work would apply.
Even if that was less favourable than the other one? So the better off test doesn't work there?
Yeah, so it comes back down to looking at the portion of work.
Wow, okay. That covers the next question as well, so I can move on from that. So yeah, I think everyone's getting a sense of the complexity of these things in practice and interpretation. How much are FPAs likely to impact workplaces that are not unionised? Well, that's an interesting thing. I mean, Julian, I think there's definitely a higher level of union membership in Australia than New Zealand. But, you know, do you see that they result in increases in union involvement in non-unionised workplaces?
Not really, because if the award applies, it applies, and you know, I guess the employee has the benefit of, you know, the terms and conditions of the award regardless. But we don't see it really having. I mean, union membership's still very much on the decline over here. Yeah,
that's interesting. It declined considerably here a number of decades ago with the change of legislation, and it's sort of been struggling to regain. So, then a question around predefined categories and jobs which could be negotiated. I think we've covered that in coverage. Hopefully, you've got a good response then. It's a bit of a wait and see, and then if there is multiple coverage, say for example delivery drivers versus your restaurant staff, how that would apply. Rosemary, this one's for you around that some associations appear to have been having difficulty in meeting the criteria under their own constitution to enable them to represent industry groups in these negotiations. Are you aware of this? And I suppose this goes to your earlier point around the complexity in being registered.
Yeah, interesting. I'm not aware of that, but I suspect that a number of constitutions that are currently drafted would not have been fit for purpose because they wouldn't have been drafted with the FPA in mind. So there will be needing to be amendments to those. Okay, awesome.
So what about for new hires? Could the process change so that they are only covered by an FPA, not an IAA? My answer to that is yes, absolutely. To avoid having, I don't think you would want to deliver an IEA that has some terms that were more favourable than an FPA and create the situation where you were navigating 2 different sets of terms. So to answer that question, my advice would be just go with the FPA. I think if you wanted to beat the FPA and be more competitive in market by, say, offering a higher pay rate, you could still do that. And that could be reflected, I'm assuming, Rosemary, just in a letter to the employee confirming a rate of pay, and all other terms and conditions are specified in the Fair Pay Agreement. Would that be right?
Correct. Yeah,
cool. Thank you. This is great. We're getting a lot of questions. We're getting a little bit of drop off now, so I think we are definitely coming to the end. Is the better off test on a clause by clause basis or better off overall after a period? It's better off clause by clause. We answered that a bit earlier. Sorry, what was the third non-mandatory example Rosemary mentioned? Redundancy, flexible work arrangements, and?
Is this to do with, that will be to do with the terms that the non-mandatory examples. Yeah, so in terms of the non-mandatory examples, we've got redundancy, flexible working, health and safety requirements.
Great, thank you. That was the third one there. Alrighty, we are approaching the hour and we have still questions coming in. We're up to 16 now, so they're increasing, not decreasing. So what I'm going to do, in the interest of time and attention, is I'm going to call it there. But we are going to keep all of these questions and we will respond to them through one of our channels. I'm not quite sure which is the best format yet, so I'll get one of our awesome marketing team who deal with communications to pick up all of the remaining questions. I will share them with Rosemary and Julian. We will provide responses and post them somewhere. Watch this space. We'll get a note out to you. But wow, that was intense and very engaging. So firstly, thank you to Rosemary and thank you to Julian. Thank you to the audience for joining us. this is a topic that is not going away. We will revisit this once we have seen the process, probably in the next 6 months. To Rosemary's earlier point around the 6-month window that MB have, expect that tomorrow there will be a whole lot of news around Unite and other unions filing for the kickoff of a fair pay agreement in specific industries. So no doubt that's going to hit you on your morning commute to work when you turn the radio on. Going right back to the start, as Rosemary said, don't panic. Right now, it's just the first step in the process, and we will watch what is going and we will going on, and we will do this again in a few months to keep you up to date. So thank you all. Really appreciate you joining us, and we will see you at the next one. Thanks, Julian. Thanks, Rosemary.